Good morning, everyone, and welcome to the Wednesday morning online seminar. Today we are joined by Mr. Jon Sharp, Consultant Solicitor for Fletcher Day. Good morning, John, all the way from
Good
Scotland.
morning, Julie. How are you on this fine day?
Good, thank you. And we are, John is talking to us about extension of time and proving delay. As always, if you have any questions for John, please feel free to ask him via the Q&A or chat facility. But if you do have something you don't wish to ask in an open forum, please feel free to email him. You'll see his email details on the screen shortly. It's jon.sharp, that's jon.sharp@fletcherday.co.uk. Okay, John, without any further ado, it's over to you.
Thank you, Julie. Good morning, everyone. Extension of time, proving delay. That's me. Less said about him, the better. All the details are on the website, etc. The starting point, as with everything, is your contract. As I say about policy wordings, those of you who've heard me talk before, you do need to read your contract. I know it sounds very obvious, but you'd be surprised at how many people don't actually read the contract. It's important that you do read the contract because, as I've said in other seminars, the courts are reluctant to interfere with parties' contractual obligations. They will do, and they'll certainly help with interpretation of wordings in a contract, but actually interfere with them, that's not something the courts do, because what they say, not unreasonably, is that basically you made this bargain between the two of you, and therefore you must have understood its terms, and therefore absent duress, perhaps, by one party to enter into it, the court's saying, well, that was the contract you made. So it is important that you read your contract before you enter into it or sign it. Essential terms, well, obviously the finish date may well be in the contract, and there may well be a mechanism for extending the end date of the contract. But also in the contract, as you'd probably expect, there will be clauses that set out the consequences for breach, in particular of the finish date. The recent trend is that if there is no programme in the contract, there's an obligation now to provide. If there's no date stipulated in the contract for the end date, there's an obligation to complete within a reasonable time. This is a common law principles, and case law confirms the following. There's Hick and Raymond. Contractor had fulfilled its obligation to complete within a reasonable time, even where there was a delay, so long as such delay is attributable to causes beyond its control, and it acted neither negligently nor unreasonably. I suppose a classic example at the moment would have been delays caused by COVID-19, so lack of labour, etc. That's a cause which was beyond anyone's control, and as long as the contractor did not act negligently, i.e. in deliberately not transferring available labour from one site to another, etc., then it will have been deemed to have completed within a reasonable time. Shortened engineering and DGP, reasonableness was to be determined at the time when the question arises in the light of all relevant circumstances. So clearly in COVID-19 times, that is a relevant factor that would have been taken into account, and indeed still may be. There's a duty to proceed regularly and diligently. There's sometimes an express term in the contract. So SABIC UK Petrochemicals Limited. The parties' contract required the contractor to proceed with due diligence and complete the engineering works in accordance with the contract. Now, the court concluded that due diligence means carrying out the works industriously, assiduously, efficiently, and expeditiously. So basically, getting on with it. That only applies, of course, if there's an express terms to that effect in the contract. If, in terms of implying terms into the contract, In the under construction against Mullally, the court confirmed their reluctance to imply a duty to proceed regularly and diligently. So the requirement must be clear, therefore it should be in the contract. As I said, the courts are reluctant to interfere with contractors' contractual rights, and they will take the view, well, look, you didn't agree that the works had to be carried out with due diligence, therefore why should we be putting that in? So it's important that if you want the works carried out with due diligence, that you say so in the contract. Is time of the essence? Time being of the essence means that the contractual provision is a condition, not a warranty or an innominate term. So time may be of the essence where the parties have agreed expressly that the time frame is strict. The subject matter of the contract considered time to be of the essence. So you're part of a construction project, I don't know, I suppose a classic example would have been the Olympic Games. It had to be completed by a certain date. Yeah. And clearly it was important that it was finished by a certain date. You were in charge of building a swimming pool and you couldn't put water in it at the time of the start of the Olympics. Well, you know, bit of a problem there. There is unreasonable delay and one party has served a notice on the other, making time of the essence in Rickards against Oppenheim. That case related to the late delivery of the chassis of a car, but even if you haven't made time of the essence in your contract, you can make it so by serving a notice making time of the essence if there has been unreasonable delay. Advantage of extension of time provisions. Well, extension of time provisions benefit both parties. The employer reserves the right to damages. The contractor is relieved of liquidated damages, but can claim additional costs associated with the delays, and neither party is in breach of contract. But extension of time provisions normally have to be set out in the contract. So there will be a mechanism, a provision in the contract, which allows either party to extend time limits within the contract. If they do so and they follow the provisions set out in the contract in relation to extension of times, then neither party will be in breach of contract. Why is a mechanism required? Well, absence and extension of time clause, an act of prevention by the employer, releases the contractor from its obligation to complete the works by a fixed date. Contractor's time obligation is then considered to be at large, and the original obligation to complete the works by a fixed date is replaced by an obligation to complete within a reasonable time. So, you have got an extension of clause, and the employer, for example, prevents the contractor from completing the works by not obtaining a relevant planning permission, for example, or not obtaining an appropriate consent to erect hoardings, for example. So under those circumstances, the contractor's time obligation is then considered to be at large. So nearly anyone's guess, but as long as it's reasonable time. Such claims were, of course, common prior to the development of standard form contracts, such as etc. The courts as well are reluctant to find time at large when the contract provisions cater for the delay, as per Setherfield UK Limited against Juro Felguera UK Limited. Okay. So if there is provisions in the contract, again, the courts are reluctant to interfere with it. They assume the parties entered into this contract willingly, they understood its terms, And therefore, again, they're not going to find time at large if there's provisions in the contract which cater for delay. Those were agreed between the parties. So is there going to be an express wording in the contract? Well, there's normally a catch-all clause. Any impediment, prevention, or default, whether by act or omission, by the employer, the architect, contract administrator, the quantity surveyor, or any employee's personnel, except to the extent caused or contributed to by any default, whether by act or omission, of the contractor or any contractor's person. Okay. However, there are a number of neutral events, force majeure being one of them. Now, this is it's not a difficult concept. Certainly in shipping contracts, force majeure provisions are common, and force majeure is a defined event within shipping contracts, especially on shipbuilding contracts. Force majeure is specifically defined. So a classic one would be an act of government that prevents the ship being completed on time. But force majeure in construction contracts is not really defined. It's just put in force majeure. People just say it. Well, that's not very good, because force majeure has no definition in law. It's just a concept. And force majeure generally is something that is outside the control of either party. So it might be a strike. No one can control, no one knew the strike was going to happen. Nobody knew it would cause the site to lock down. It's a force majeure event. Same with acts of government. So, for example, in a shipbuilding contract, perhaps putting a limit on how much steel could be imported to a country. So force majeure has to be two things. It has to be outside either party's control. It's something that's just happened. Yeah? But better contracts define force majeure. So what will amount to a force majeure event? Otherwise, you end up going to court saying, there's force majeure in this contract, but it's not defined. Was this a force majeure event? So it's better in all contracts if you define the term force majeure, or what might be considered to be force majeure. Exceptionally adverse weather, snow, ice, consider NEC4 approach, where a 1 in 10 years event is a delay event. So I suppose the beast from the east would have been a delay event. And statutory undertakings. So, completion of works on a site is prevented because someone's got to go and put some new drains in or some new electricity supply, something. Excuse me. The requirement for serving notices is usually on direction and not mandatory. Temlock Limited against Errol Properties Limited. The requirements for a condition precedent under English law were established in Braemar Handel Gesellschaft. I said that very well, I think. Against Vanden Avenue Isgem, not so well. Precise and clear timetables must be identifiable, and the result of missing the timetable is clearly spelt out. Again, comes back to definitions within the contract. There's no point in setting out a timetable and then not saying what happens if you don't stick to the timetable. So you have to have both. You have to have precise and clear timetables, which must be identifiable, so by reference to an appendix to the contract, for example. And then in the contract, there will be the result, there will be a definition of what happens if the timetable is not complied with, and that should be clearly spelled out. Again, and I keep going back to this point, the courts are reluctant to interfere with clearly drafted condition precedent clauses if the requirements set out in the notice provisions are clear. Again, it goes back to the point I really started with. The courts don't interfere with contracts willy-nilly. Yes, they will certainly assist if neither party can understand a particular clause in the contract. There's a procedure called Part 8, where you can apply to the court almost neutrally between the parties and say, look, we entered into this contract, nobody disputes that. This is the clause in there. We are not sure, either of us, what it means. Will you courts assist in our understanding of that clause? That's fine. The courts will go, okay, well, then we think it's this. But what they won't do is interfere with clearly drafted condition precedent clauses, or indeed any other clearly drafted clauses in a contract. It's not their job. They assume the parties knew what they were doing when they entered into the contract. They assume that it was negotiated properly, and therefore they're not going to interfere with clearly defined clauses in any contract. So the contractor must ensure that they comply with any procedural requirements in the contract regarding the form, content, and timing of the notice. Very often in contracts, there will be a provision that says, well, that first of all says what needs to be in the notice, and secondly, about service of the notice. So how do you give notice to the other side? Can you do it by email? Do you have to serve it by letter on their registered office? Do you have to give it to them by hand? So you need to read the contract if you are about to give a notice to find out, first of all, what you need to put in the notice. And secondly, how you go about serving that notice on the other side. Those are all normally set out in the contract. And be careful, because in many contracts, it is not, if you like, the offices or the warehouse of one party. It will normally be their registered office. It may be that a registered office is just basically a hole in the wall, but you must comply with the contractual provision with regard to service of notices. So in Stereo Limited against Sigma Wireless Communications Limited, the court decided that notice requirements and extension of time mechanisms do not need to contain a warning that failure to comply with the clause will result in the contract losing its entitlement to an extension of time. So you only need to set out what's in the contract and serve it properly. You don't need to go further and put a warning in. That's not necessary. Now, the employer is free to suspend or waive notice requirements as well. Can be waived by silence or contact, as per City Inn Limited against Shepherd Construction Limited, where both parties ignored the notice requirement. I have to say that's a slightly unusual concept. You've got clear notice provisions in the contract, and then you just don't bother to do any of them. Well, then you'll be deemed to have waived that, which can, of course, have consequences. Excuse me, ladies and gentlemen. Apologies. Rejection of extension of time. What happens if the employer rejects or does not deal with an extension of time? Two options as decided in PBS Energo AS against Besta Generation UK. The contractor can refer the issue to adjudication. That would be probably the most sensible, cheapest option to choose. Adjudications, as I'm sure everyone knows, are quick, and they are still much less expensive than going to court. Court fees alone on a claim of, I think, over 100,000 are now 10% of the claim. So you're paying £10,000 in court fees. Forget solicitor fees, you're just paying that in court fees. So adjudication is probably a much cheaper option at this stage. And as you know, adjudication decisions are readily enforceable by the courts. Because otherwise, potentially, you're going to end up in a termination dispute. And that's going to mean court fees, litigation. And with the court delays at the moment, not the court's fault, caused by COVID, you'll be in court for still now at the moment, probably 2 to 3 years, whereas as everyone knows, an adjudication, 2 to 3 months, possibly less. So what are the consequences of failing to complete on time? Well, the obvious one is damages, which can be liquidated or unliquidated. So either in a fixed sum or a not fixed sum. And of course, termination of the contract. These are obviously quite serious consequences. And therefore, you need to ensure that you do everything in your power to complete on time. Now, in terms of proving delay, well, there are some questions that need answering. Firstly, what was supposed to happen? So what, for example, did the contract say? What was the completion date? Is it clearly set out in the contract? Was there any room for maneuver? But normally, there will be in the contract a date for completion of the works. Fairly straightforward. You must complete the works by. Then the courts will look at, well, what did actually happen? So it was supposed to complete by this date. It didn't. Well, okay, why not? What happened? What prevented completion taking place on the date set out in the contract? What are the variances? So, how late was it? Was it days? Was it a week? Was it months? So, what is the variance between what was set out in the contract and what actually happened? And how did whatever happened affect the project schedule? The contractor often has to establish entitlement to an extension of time under the contract. Again, there may be provisions in the contract which set out when the contractor can claim an extension of time. But he's got to establish an entitlement to it. Therefore, it's much better if there is a clearly set out clause which deals with extension of time in the contract. The contractor also must demonstrate that delay was caused by the relevant event, giving rise to the claim for the extension of time as a matter of fact. So the variation instruction, the employer wants more work done. Right, I know we agreed we would only do this, but I want you to do that now. Okay, well, that's fair enough, but that's going to take me longer to do as a contractor, so I need a bit more time. Not unreasonable. The employer's active prevention. So yes, he hasn't got planning permission for hoardings, hadn't got the relevant permits to enable the work to take place, etc. Or the force majeure event. But as I said earlier, I'm cautioning you all now about force majeure. Doesn't tend in contracts, sorry, building contracts at least, to be particularly well defined. My advice has been in the past, and it still remains, that if you're going to have a force majeure clause in a construction contract, you need to define what that examples of force majeure. Don't just say force majeure. That's not good. You're going to have to go to court to see whether it was a force majeure event. But putting in events, and in particular in the light of the last couple of years, pandemics, acts of government, etc., those may well be worth putting in. You could do it as an appendix to a JCT contract. So force majeure is defined as, or examples of force majeure events are. Yeah. But put it in. And also put in relation to force majeure, what the consequences of force majeure are. So if it is a force majeure event, what is it that means? Does it mean the contract's extended by a certain period until the force majeure event passes? What? What does it mean? As I said, in construction contracts, force majeure is poorly defined, and very often the consequences of it are not set out in the contract. The contractor must then prove the effect of the relevant event and isolate these effects from the other potential factors impacting the works. Okay. The contractor must demonstrate mitigation measures to prevent the delay. So to satisfy the obligation to constantly use his best endeavours to prevent delay in the progress of the works, however caused, and to prevent their completion being delayed or further delayed beyond the relevant period for completion. That's a standard JCT requirement. Mitigation is only required to the extent that it reasonably saves costs and prevents delay. So you need to bear that in mind when mitigating your loss. It's only required to the extent that it reasonably saves costs and prevents delay. Okay? It may be that you could have prevented delay, but the outlay or the cost of preventing the delay fully is hundreds of thousands of pounds. Well, no, but there may be other things you could do which would reasonably save costs and prevent delay. The contractor must be able to produce evidence to substantiate the truth of its submissions concerning the cause of the delaying event and its effects. So it may be that the contractor can't get electricity to one part of the site. Now, that may be, through no fault of the contractors, that may be an event that the contractor can't rely on. A common problem with particulars submitted to a contractor administrator in support of a claim under the contract for an extension of time and in subsequent adjudication is a contractor's failure to present all the relevant facts substantiated by evidence. Now, this can be a long and laborious job. Excuse me. But that job's often made easier if there are good and contemporaneous notes, good minutes of any site meetings, good minutes of any meetings between the employer and the contractor, made contemporaneously, so not made months later, but made at the time. So it's always important that if you're on a major construction contract, to keep a record of what actually happened, rather than have to then go back with nothing to work on, no notes, no minutes, no nothing, and just rely on people's memories. The better policy is to make sure that detailed notes are kept at the time, and in particular, if there is a delay event, narrating what caused the delay and what, say, the employer's reaction to it was, etc. So much better to keep contemporaneous notes, because even though it's time consuming at the time of making them, it will ultimately, if there is a dispute, assist greatly. And the courts like contemporaneous notes. They like to see, well, this is a record of the site meeting was made the next day by me. That's good evidence that that is probably what went on at the site meeting. So there's 6 methods to prove delay: impacted as planned analysis, time impact analysis, time slice windows analysis, as planned against as-built windows analysis, retrospective longest path analysis, and collapsed as built analysis. Impacted as planned analysis. It's an overview, measures the impact of the delays on the contract as planned. Various delays are formulated as activities added to the as-planned network in a chronological order, showing the effect of each delay, dates between the networks before and after the impacts. Pros, it's simple and inexpensive, popular for prospective analysis. Cons, uses fixed as planned network to analyze out of context and time. The original baseline may be incorrect or not realistic to base whole analysis on, and may fail to consider all delaying events, and there are disputes as to the adequacy of the as plan. Time impact analysis, get an overview, introduces delay events into the baseline program, uses contemporaneous programs to anticipate delay. Advantages, well, updated contemporaneously, and it can accurately predict revised overall completion dates. Cons, need to verify baseline information to show durations were reasonable, realistic, and achievable with proper logic links. Does not factor in mitigation or acceleration measures. Time slice window analysis requires contemporaneous programs throughout the project. The time slices are reviewed regularly, usually monthly, and this reveals the actual critical path based on monthly progress. Advantages, accurate analysis based on solid records, can provide a robust position which is difficult to undermine, can divide a complicated program into a coherent structure. Disadvantages, and again, it requires accurate records. The analysis must still prove baseline durations were achievable, and it's time consuming and costly. As planned against as-built windows, usually used where there is concern over baseline program, breaks the duration into windows, which is then analyzed using records, common sense and practical approach to delays. Advantages, well, it can be an accurate assessment. Disadvantages, more input from the analyst rather than software which can be manipulated, requires good records to be effective. Going back to my point that I made at the start of this section, keeping good records is still of real value. I accept that, you know, it's a pain, but if you do it and you do it well, then it really does assist. Retrospective longest path analysis. Overview, detailed as built program required for review. Trace the longest path backwards from the end to determine as built completion. Compare the key dates between as built and planned program. Again, it can be an accurate assessment, but disadvantages can be difficult to track and allow for changes in the construction program. Requires good records to be effective. Again, most all of these methods require good records. So there has to be some solid data upon which to build to use any of these analyses. Which is the correct technique? Well, no straightforward answer, as the Beach principle relies on the information available and the intended budget. Again, back. Well, what have we got? We've got 1 minute of one site meeting. That's not going to do anyone any. The techniques as employed have been a source of contention because they yield different results, obviously. The available records, again, are key to deciding what method to use. If you've got really good, detailed records, you can choose which analysis you use. If you've got no records, you may be forced to use one that perhaps doesn't assist you greatly. Balfour Beattie against the Mayor and Burgess of the London Borough of Lambeth. The adjudication decision was challenged as the technique was not afforded commentary by the respondent, and the respondent's position was upheld. Also, see the case of Ascon Contractors Limited against Alfred McAlpine. And again, you see, wholly theoretical calculations will be unlikely to succeed, surprisingly enough. If, when asked a question on what did you base your analysis, well, I used common established theories. Oh, so you didn't actually have any records to base any of your analysis on? No. Well, courts really won't like that. So again, it goes back to my point at the start of this section that keeping good and accurate records is always important. It will provide you, in the event of a dispute, with being able to choose which analytical tool you use. And if you have good supporting documentation, then it's likely to sit well with the court. They're very unlikely to say, oh, well, that's a load of rubbish. No, it's not, because here is all the supporting evidence behind it. So again, keep good records. In Skanska Construction Limited against Kavanagh Construction against Eager, His Honour Judge Wilcox observed that the sophisticated impact analysis of an expert was only as good as the data put in. Again, good records lead to good analysis, which is substantiated and which is difficult to argue. If you've no data to base any analysis on, it's not going to be it's not going to carry much weight with the court. So again, if there's two things that come out of this talk, the first is read the contract. Because I've stressed, and I hope it's been made clear during this presentation, the courts are unlikely to interfere with what the parties have agreed. As I said, they will help them understand what they have agreed. That's a different matter. But they won't interfere with what's been agreed, and they won't imply terms into contracts if the parties didn't put them in there. In addition, keeping good records of the construction project, how it progressed, is vital. Without the records, you're unlikely to succeed. With the records, you stand every chance of succeeding in the event that there is a dispute. That's all I was going to say, ladies and gentlemen. Thank you very much indeed for your attention this morning. And where's Julie gone? Hello, Julie. Oh, she's there.
Back in the room, John. Don't worry, I'm not far away whenever you're on screen. We do have a question, which is, hi, regardless of the type of delay, is there a time span to which the contractor should notify and provide all relevant substantiation about the delay? Say they've notified there'll be a delay of X days. Are there now deadlines they have to adhere to?
It goes back to the reasonable expeditious point, really. If you do notify of a delay and say it is accepted by the employer, so there's no argument, yeah, okay, we understand what's gone on, you still have to proceed as expeditiously as possible. You can't just sort of say, oh, good, they've agreed a delay, so we'll hang about for a few more weeks. That's not how it works. Even if a delay is agreed, and very often they are, you've still got to get on with it and not make the delay even worse. So you've got to proceed expeditiously. In terms of fixed time, it's nothing fixed as far as I'm aware in law. It goes back to, yes, you've agreed that there's been a delay, but you've still got to then get on with it and mitigate how long the delay lasts. You can't just say, oh, good, he's agreed to another 4 weeks. That's fine, we won't do anything. You've got to get on with it. It's the expeditiously and reasonably diligent point.
Okay. Someone else is asking, what about pre-construction? How would a contractor demonstrate this? The question is where you still have a delay even though you started earlier.
Oh, that's quite tricky. Well, I think probably the same principles that I've set out in this talk apply. Even if you started early and then you then encounter delay, it doesn't really make any difference. It will certainly help the contractor if there is a dispute, because he will be able to say, well, you know, this delay, very sorry about it, but it's not as if we didn't get on with the job. We started before we were supposed to. We progressed the matter as quickly as possible. We didn't hang about. We didn't start at the 11th hour here. We got on with things early to try and avoid any delay. So, yes, it would certainly assist. But again, I'm not sure there's any hard and fast legal principles, but starting something early and then encountering delay, well, you know, that is going to look good on the contractor because he was clearly trying to stick to his contractual obligations by starting the work early. So,
again, I assume records, etc., discussing the early start would be.
yeah, again, a good, accurate record of we started early because and we started on this date, which was 2 weeks before contract. We got on with the job, and then we encountered delay. Well, it's going to be good because if you'd started on time and not early, and then encountered the delay, there would be more delay.
Yeah.
So I think that's the way to look at it.
Okay. Someone else is asking, how would a contractor claim for a delay in delivery of materials, which is obviously quite a relevant one in the current.
It certainly is. As you know, Julie, you and I did a talk last November on what the likely impact would be. And as you know, I said it would be labour, it would be cost of materials, and it would be supply of materials. And regrettably, I was right. You might, well, first of all, two things. You can buy insurance policies now, which do cover you for delay in supply of materials. In terms of if there is a delay in supply, you could possibly argue that there's a force majeure event. I think it's unlikely to succeed, but you could at least try and argue it. But again, it's probably a delay event. It is going to be more difficult to obtain materials, especially timber, going forward. So I think it's important when you're agreeing contracts in the first place that you build in additional time. And there is nothing to stop you putting a clause in the contract at the start to say, you know, one of the acceptable reasons for delay is the delay in supply and materials. I think increasingly they'll be more common. I'm not saying this will continue forever, but I think at the moment it would be very reasonable for both parties to accept that if there is a delay in this arrival of materials so we can start work on site, then that should be something that's accepted by both parties as a matter that's effectively outside of their control.
Yeah.
That said, if you are using a more collaborative type of contract, so the JCT Constructing Excellence contract, for example, that envisages talking to suppliers, etc., before the start of the works, so that the works proceed smoothly. Very often in construction contracts, there is no real contact with suppliers. An order's put in and no one's spoken to the supplier about that, because then he'll turn around and go, well, if you'd told me 6 months ago, I could have got it already. But at the moment, I've got no chance. So.
Okay. All right. Well, that seems to have cleared all the questions this morning. So thank you, everyone, for attending. Great to see you all, as usual, online. We have another presentation this evening at 6, where we are joined by Richard Silver, who will be discussing the question, what is concurrent delay? So if you would like to book a place on that, please don't hesitate to drop me an email, seminars@fletcherday.co.uk, and we will book you in. John, many thanks for your time this morning.
No problem.
Glad to see you survived the horrendous rainfall up there last week.
Oh, yes. We didn't have rain.
Without any damage. And we will see you again very soon. Thank you.
Thanks very much, Julie. Thank you, everyone. See you,
Take care.
Julie. Bye.
Bye.